these revised rules and regulations.
It should clear the air on the law expanding the Good Conduct Time Allowance policy. But a lawyer group says the revision of implementing rules and regulations is open to serious legal challenge.
So we feel that wittingly or unwittingly, despite good intentions, presumably, it may be tantamount to executive legislation.
Section 1 of the law expressly excludes heinous crime convicts from availing of good behavior credits to shorten jail time. But Section 3 has no provision about this, and this was reflected in the old Implementing Rules and Regulations, or IRR.
Because the water cannot rise above its source, the rules and regulations cannot expand or even emasculate, for that matter, what is in the law.
National Union of People's Lawyer President Edre Olalia says the new IRR deviates from the purpose of the law.
It should benefit the accused. So if you apply those exclusions as the law stands now via an IRR, then that is expanding or stretching an exclusion to the prejudice of those who would deserve to be granted the time allowances.
Before Republic Act 10592 was passed in 2013, heinous crime convicts are entitled to lesser time allowances under the revised penal code. But those charged and convicted after the law took effect, they're barred from receiving any type of time allowances.
We cannot use the bad examples of Mayor Sanchez, and I agree that he should not be freed, or even the convicted accused in the Chong sisters, as the barometer of whether or not this good conduct time allowance must be applied.
Justice Secretary Menardo Guevara says they are ready to defend the new IRR.
Now, if there is any constitutional objection to excluding certain classes of PDL on the ground of equal protection of the law, then any person who is minded to challenge the law itself should go to the appropriate judicial forum.
While the administration is prepared to face any legal challenge to the new IRR, who will stand up against it in court? Anjo Alimario, CNN Philippines.